Hi, good evening. Today is October 22nd, 2025, and it is 6:28 p.m. U.S. Central Time. And my name is Rinaldo J. Aguiar Marcano. And I'm recording this video from my home located at the 26714 Valley Side Drive, Katy, Texas, 77494. So I wanted to make this quick video. It's kind of an addendum to the previous session. And I want to dive deeper into the technical topic that I was mentioning at the end about, if I can put it in words, in technical words, it would be I'm basically making a case or making the case for the need of turning the legal dockets in the public court systems into structured data that it's understandable by any human being without having to pass the bar exam. So I want to deep dive because I think, at the end of the previous session, I mentioned the idea, but I did not make justice to the idea really, because I didn't want to dilute the previous topic, right, with technical jargon. But this is a really interesting. I think it's a really interesting idea, right? And I did not make justice to it previously, so I wanted to make this quick addendum to kind of go deeper into it, right? So what I was saying is that if you take actually, let's do this example, right? Let's do this. I'm going to share my screen, okay? And so you have the visuals of what I mean, right? So I'm going to go do a Google search, and then I'm going to search for Fort Bend County civil court records. Right? So in the US, at least, right, pretty much every court has the equivalent to this. I think it's this one. Right. So this is the case in question, right, where Judge Telfair is presiding. So if you look at this docket, right, so you see the documents that have been filed, and it's just a list of documents, right, sorted by the time or the date in which they were filed. See, this is the. Oh, this is interesting. Okay, no, this. Yes, so this hearing on November 10th that they have set is because this is the date the temporary orders that they verbally gave but never signed are set to expire, right? Yes, and this is the response I filed today, objecting the new fraud that they're trying to commit with against this court, right? By saying that I agreed to something I never agreed to. And here you can see that, right? You can see that they're saying today on October 22, they filed a motion, Index 95, saying that implying that we had an agreement on a motion to withdraw the console, which is not true. Right? I didn't agree to anything, and I will never agree to that. So, but anyhow, back to the technical topic, right? So if you look at this, right, and you see the problem right here in what I just did, I had to read the titles and parse what it meant, right? I had to understand, and you see, for example, this thing that says notice of entry temporary orders, right? Like I have to know what a notice of entry is, right? And this is a specialized knowledge of the legal profession, and I have it because I've been exposed to this problem for 6 months, but I didn't have it 6 months ago, right? 6 months ago, if you had asked me what notice of entry meant in a legal docket, I could not have answered that question, right? 6 months ago. And the other problem is that I'm here only doing the titles, right? But if I click on this, right, I think it should probably show you the document I filed today, right? Right. So if I show you, so then you have to read this and you have to understand, right, from a legal point of view, the implications of what I'm saying here, right? This is a task that not every citizen can perform. Not because they're not smart, but because they lack legal training, right? There are people that come from all walks of life. They could be doctors, they could be factory workers, they could be anything, right? Regardless of the level of education, they don't have legal training. So even if they read the document, they will probably make a mistake. They will have misconceptions after reading it. So it's inaccessible. It's a set of information that, although it's public, is not accessible, right? And I think we need to start making the distinction between what is public information and what is accessible information. Those are two different things, right? It's like, and it's kind of funny to think about this because the government, and not only in the US, in every single country, developed country, right? Governments have been doing a push for, and I know this because at Google, when I worked at Google, we did a lot of projects related to this, right? To accessibility. Making information accessible to people of all abilities, right? Meaning, even if you're impaired in some way, or if you're blind, if you have difficult seeing, if you cannot hear, the information needs to be accessible to you, right? But whatever means necessary. And companies like Google go to great lengths to make that happen. But you see, this is another kind of impairment. I mean, I don't know if that would be the right word, right? But it's another kind of the same situation in which the information might be out there, but you are not able to consume it because there's a barrier of entry that you cannot overcome, right? In this case, is the knowledge of legal jargon and legal concepts. So I was saying that one possible solution, right? And I was going to write a quick demo of this to show, but I have so many things to do that don't have the time right now to do it, so I'll just explain the concept. But imagine that in this docket, this is called a docket, right, or a case summary. Well, here they call it register of actions, right? Right. And this is another thing, right? Sorry for diverting, but it caught my attention, and I don't know if this would be another procedural violation, right? But in that motion that they filed today, right, which is index 95, right, where they say that we are agreeing, we haven't agreed to anything. Well, I cannot download it because, of course, they set all their documents to private, right? They cannot be downloaded, so the fraud cannot be seen by anybody. But if you download it, right, it will say, and it's signed by Morgan Heitner. And I don't know if this will be a procedural violation, but according to this, the lead attorney is Troy Pickett, right? So shouldn't be Troy Pickett filing these things? I mean, why? I guess the question is, why is Troy Pickett the lead attorney if he's not doing the actual work, right? And putting his name on the documents they're filing, right? It seems to me like it could be a way to dilute liability because then one is the lead attorney, but then the other is the one that files. So neither one is accountable, right? Because each one can say, well, I'm not. So Morgan Heitner can say, I'm not the lead attorney, right? So talk to Troy Pickett, and Troy Pickett can say, I didn't file this. Talk to Morgan Heitner, right? And that way, nobody's on the hot seat, right? For this fraud committed today, saying that I had agreed to something that I did not agree. But anyhow, back to the technical topic. The conversation was, imagine that in this docket at the top, there is a table, right? Computed by automated means by software that turns everything that is in this docket, not only the titles and the dates, but also the contents of the documents, into structured data, right? Using technologies that are well-known technologies at this point, like entity recognition, sentiment analysis, inferences, and statistical analysis, right? So the idea would be to build a table that has all the parties in the case, right? So in this case, it would be plaintiff or petitioner and respondent, right? And it would have a high-level statistics of the number of motions that were submitted, the number of responses, the number of notices, right? And out of the motion, so the things that the judge has to rule on, either objections or motions, right? Then compute high-level statistics of how many has the judge ruled on, reviewed, and ruled on for each party. And out of those, in how many were favorable or disfavorable decisions to each party, right? If you build this table, it will give anybody a high-level, very quick overview of what's going on in this case. Like if you build this table that I'm describing for this case, you will see that all my numbers are in zero. This judge in 6 months has never ruled in a single motion I've submitted. It's like I filed the motions and they go into the void, right? He never replies, he never, nothing. There's no response. It's like I don't exist, basically, right? While in contrast, Morgan Heibner, every single time she files a motion, she gets a response, and it's always favorable to her, right? Except two exceptions. One is when she asked for the psychiatric evaluation, but I mean, that motion had a bunch of different things, and the only thing that did not go through in that motion was the psychiatric evaluation request, but the rest, she got everything, right? Including the supervised visitations, the sole conservatorship of the child, everything she got, right? Everything she asked for, she got, except for the psychiatric evaluation. But the most telling thing is that her motions get processed, right? If she files a motion, it gets processed immediately. If I file a motion, it never gets processed, unless it's a motion to recuse. Those are the only two motions. Well, only one, really. The one that I filed on July 2nd got processed. The one that I filed on October 16th, the procedure was stayed, but I don't know if it, I mean, I haven't received a response. So far, it hasn't been processed either, right? So of all my motions, only one has been ruled on. So the idea is to build this high-level statistics table as a summary that will allow anybody to see what's going on in this case. And this promotes real accountability because a judge has to respond, because of course, otherwise this number will basically look bad for the judge, right? But in the way it is right now, you see this and you don't know what's going on here, right? Unless you are in my shoes. That's the only way you would see what is going on, right? Because you would know that every time you file a motion, it never gets any kind of answer, nothing, right? Not even a negative answer. It would be better if you gave me a negative answer, because then I know, right, what to do. But they don't give me any kind of answer. Then I think that is part of the psychological, attack. Now, but going deeper into this, I also want to say that this goes beyond the individual cases, right? Because after you have those high-level statistics computed from structured data, then you can aggregate them across cases, for example, for the same judge, right? So you can aggregate, you can do the aggregation of all the petitioners that this judge has served and all the respondents that this judge has served, and you can find deviations. Because the question is, I mean, the next question would be, is that this judge always does this, right? That always rules on all the motions for one party and none of the motions for the other. If that's not the case, it is a red flag, because it means that there's bias against this particular party, right? And if it is the case, it is also a red flag, because this means that this judge is not doing his job, right? I'm talking hypothetically, right? The two possible scenarios. But either way, it's useful information to aggregate these high-level statistics on each case at the judge level, okay? To find a statistical anomaly, right? Because the thing is that these kind of distributed attacks that they do with the Morgan Heibners and the Troy Picketts, and as you see, they imply collaboration between multiple individuals interacting in the same societal system. And the only way to detect those interactions is with the statistics, right? Because those interactions create statistical anomalies, as in this case, right? The statistical anomaly is the judge didn't rule in any of my motions, right? Written or verbal. Like, to the point, on October 10th, I objected on the record verbally, and he ignored the objection. He didn't rule on it. He didn't say sustain or overrule. He just proceeded to ask me questions about the substantive matter without ruling on the objection, right? So even if I do it verbally on the record, he will not rule on my motions or objections, right? But the important thought there is that the only way to detect these collaborations that they do is through the use of statistics, right? Because the statistics don't lie. If the judge doesn't behave in this way with other respondents, it means that this is something targeted, right? And if he behaves in the same way, it means that he's not being efficient at his role, and somebody has to review that, right? And then you can also aggregate it at a higher level, right? So you can aggregate across all the judges in the 387 district, right? Judicial district, and compare them to other districts, right? In Texas and in the country, for example, right? In other states. And this will tell you if a system is compromised, right? So depending on the level of aggregation that you achieve, you would be basically debugging a different level of the society, right? And out of this professional circle in this case, right? So it's basically the use of statistics and aggregation to detect anomalies, which is what the pipeline does, right? Like if you think about it, the pipeline doesn't only go by is the address of the house marked in the geoindex, right? Because that alone, I mean, it could be the previous owner, right? That was marked in the index. But if the house is marked in the index and the car has a bigram that is a well-known bigram in the license plate, and the vehicle has certain features, right? And they also download data from my car or from the box they have in my surroundings as they pass next to me, like if you add data points, you can get to the conclusion with high confidence that yes, this person is likely part of the network, right? Well, it's the same here. It's not that the statistical anomaly itself is going to be a proof, right? But it could be an important data point. And if you see that it's something that repeats and repeats and repeats, then you can draw a conclusion from that, right? But so I guess what I'm trying to say is that introducing something like this will be good because for twofold, right? Threefold, really. One, it would make the information not only public but really accessible to the citizens, right? People that are not lawyers. Secondly, it will promote transparency, and it will deter bad behavior, right? Because if a person in a position of power knows that these statistics are available, right, and are being computed and looked at, they will be less likely to do this kind of abuses, right? Because they know that it could be discovered, right? It could be obvious. But also importantly, having these statistics even at the case level allows for aggregation at higher levels, going all the way up to the Supreme Court, right? And that it's a powerful societal tool to fight against these type of networks, right? Which, as I said before, like even if you dismantle this, they will do it again, right? Like they will do it, they will rebuild this in a more sophisticated way, more difficult to detect, right? So the world really needs to start thinking on not only countermeasures on how to dismantle what they have right now, but also how to prevent this from happening in 20 years from now, right? I think that is the end game. Well, anyhow, just a little bit of food for thought. So I'm gonna close this quick session, and I'll see you on the next one.